I thank the gentleman. The chair now recognizes a gentleman from Minnesota, Mr. Paulsen, for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here today. In today's world, when we talk about moving information between systems and making it more available out there, we have the issue of identity theft, of course, and the protection of personal identifiable information, which is sometimes called PII. And that is a primary concern whenever anyone talks about expanding access to data. I'm just wondering, Mr. Blinn, you touched a little bit about this right at the end of your testimony, I think, but can you please walk us through exactly how the privacy protections provided by the draft legislation language would work if researchers were given access to data in the National Directory of New Hires? And what other types of federal data do researchers already have access to? What privacy protections surround that data? Have they been effective? How do those protections compare to those, as an example? And is there any reason to believe overall that these privacy protections would be any less effective than those that are in place right now involving other areas of federal law?
Do you want to go first? Yeah. Okay.
Go ahead, Mr. Blinn. Yeah.
Well, I can describe briefly the steps that we take, and we work with a lot of other firms that also do this kind of work and have typically found that they follow very similar procedures. We have a chief data security officer and a data exchange manager. We begin by meeting with and working with the agency and identifying the most reliable, safest way to actually transfer the data. And that data transmission method usually follows the National Institute for Standards and Technology's strict standards for data. It's called for data in transit. And it's a pretty standard protocol, and NIST has established a set of very strict rules around these things. And I think you want to make sure that those kinds of rules are what the agencies are relying on and using, and that's typically what they are using. Those data teams then work with and store that personally identifiable data on a secure, centrally located server. It can only be accessed by a limited number of people. Once we have the data, the very first thing we do is strip the data of all personal identifiers, and we create essentially a random number for every individual in the data set. That's the data set we work with. The data set that has these personally identifiable information on it is set aside in this secure server that's controlled by basically a data security officer. There's almost no reason for us to be using that data set on a regular basis. At the end of the study, we then use the National Institute for Standards and Technology standards for ensuring that the data is destroyed in an effective way, that it can't be located elsewhere. As I said, most firms use those same kinds of procedures. At our organization, and to the extent that I know of other organizations, there's never been a breach of any of that data. We get, and some other organizations we work with actually get Social Security Administration data, which is even more if you think about, we're only talking here about knowing quarterly earnings, essentially. The Social Security data on disability and other things are much more sensitive. And we do get that data now, and we meet a very high standard for that data. Federal agencies generally have compliance officers who visit your organization and really confirm, unannounced, and confirm that you're in fact following all of these procedures.
So the data you would use as a researcher under the scenario or under the draft legislation would be just as protective of privacy concerns as it is for other federal agencies use right now.
Exactly. I mean, the truth is, the thing everyone seems to have forgotten here is we already have this data. Yep. We're just getting it from the states, and we have to, we follow these procedures now. And for 30 years we've been doing this. But again, at great unnecessary cost because the same data is already sitting at the federal level.
And Ms. Farley, can I just follow up and ask, I think you may have mentioned privacy protections within the Hague Convention, but can you please tell us a little bit more about those?
Yes. The drafters of the convention were very aware of the personal information that would be gathered and transmitted. There are several provisions within the convention that deal with this issue. One, protection of personal data. Any personal data that's gathered and transmitted can only be used. It's restricted to be used only for the purpose in which it's being gathered and transmitted. So someone getting information for collection of child support could not hand that off to some other entity to use it for another purpose. There's also a provision related to confidentiality in that the participating countries must protect the information that they gather in accordance with their national law. And the third one has to do with non-disclosure, and it's a sensitivity to domestic violence. And so authorities are prohibited from disclosing or confirming information that would jeopardize the health, safety, and liberty of the persons. The other thing I would mention is as the treaty was developed, tools were also developed to help implement it, including a set of forms, recommended forms. And all of the recommended forms clearly identify what information is personal and should not be transmitted, and should be, that the country should be very careful in handling.
Thank you very much, gentlemen. This time has expired.